All right, good afternoon and welcome. We today call to order the November 12, 2021 meeting of the Delaware County Board of Elections. I'm Gerald Lawrence, the chairman of the Board of Elections. With me are Ashley Lunkenheimer and John McBlain, fellow members of the Board of Elections. Our agenda, the first item on our agenda is the Pledge of Allegiance. So if we all rise.
Sure. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So, good afternoon. The next item for consideration is the agenda itself. It's been distributed both online. It's in the back of the room. Does anybody on the board have any comments about the agenda?
No.
All right, so I think we're ready to then proceed with the meeting. We don't yet have minutes from our meeting of 2 days ago, so we don't have any minutes for consideration or approval today, which brings us to item 5, which is Mr. Allen's report.
Good afternoon, Mr. Chairman, board members. The only notable item that's occurred since our last meeting has involved the Department of State giving a directive that next week we will need to commence with a statewide recount for the contest of the Court of the Commonwealth. And that's going to be a very involved process. We had a conference call of our management team and Hart Intercivic to try to map out what our preliminary requirements were ahead of the statewide conference call at 10 a.m. this morning with the Department of State, which had virtually all 67 counties on the phone asking questions about how best to proceed, because this is, for all of us, the first state or statewide recount of all the counties since 2011, and for all of us, it's on newer equipment, and there have been changes in the law since that last recount in 2011, 10 years ago. So it's going to be it's complicated, but the short version of it is that we have to recount all of the ballots that were cast in the precincts on equipment other than what was used in the precincts, meaning we can't use the precinct scanners. We'll be using the high-speed scanners for the election day ballots. Similarly, the vote by mail and absentee ballots have to be processed on not the high-speed that we have. We have two alternatives. A newer version of high-speed that's been certified by the state that we would get on a loaner basis from Hart Intercivic, or the ballot scanners. The downside with using the ballot scanners is they're much slower, and we're talking about processing 35,000 in a 4-day period. It's going to start on the 17th. There are legal notices that we need to provide to the campaigns involved in this matter and the county political parties. The goal is to have by Monday, so we're going to be working through the weekend on this, trying to work out the staging of this at the wharf, as well as to, if possible, at least have a walkthrough for our staff, where we're going to position people, where we're going to have space for observers, and how it's going to proceed. And if at all possible, we're going to try to squeeze in, ahead of that Wednesday the 17th start, the ability for the parties to see how we're going to stage this out at the wharf with both the in-precinct ballot bags and then the vote by mail and absentee ballots. So we got a heavy lift ahead of us in addition to everything else that's going on right now. And in the middle, and so we have to complete that recount in my estimation 4 days, even though we have until the 22nd. I don't believe we should map it out that way, because if there's a power outage or some other disruption or an equipment problem, we need to try to shoot to get that done at least a day in advance. So it's going to be a heavy lift, because it's not only 140,000 or however many were cast in this election, but it's 140,000 A's and B's, since this was a 2-page ballot. So
Oh, I
we
didn't
don't,
realize that. So it's not, we have to
there's no way,
recount
there's no way to separate out the
the
bees.
one race. We have to recount the
We're just gonna have to run them
retentions, too.
all. And
And do we only report the one race, the Commonwealth Court race? We don't report all the races, correct? So even though we're scanning everything, we're only tabulating that, the race that's subject to the recount.
yes and no. So we may be reporting all of them. The only ones that we're going to be concerned about if there's an undervote or an overvote will be
Commonwealth
the
Court.
Commonwealth.
What about the individuals? I heard reports from some of the polling stations that not everybody cast their page B. So you will have, I'm sure you will have some missing page Bs.
We've been aware of that since day one. We included that in the training. So yeah, if, for example, and again, I don't recall the latest total of ballots cast, but if there were 140,000, I would expect that there might be only 130 or 120 of the Bs. Some vote by mail, and absentee voters didn't return the, and page B for anyone in the audience was the judicial retention questions. That's the only contests that were on that page B. Some voters, and I heard this from all areas of the county, just simply refused to vote the B. They asked questions like, you know, how come there aren't political parties on these judges' names? And these were things that we instructed the poll workers, you cannot, you know, electioneer in the polling place and answer questions like that. But we had processes involved so that they could deal with abandoned ballots in that case, so that they put them in the spoiled ballot envelope, but they didn't spoil them and issue a new one.
And then, Mr. Allen, on your comments before, I think it is imperative that we have some procedure at a minimum the day before we start, or the afternoon, the evening before we start, so that political parties can come in, see the process, ask questions, so that when we start counting, they're comfortable with what's going on and they are in proper position to observe it to their satisfaction. So I think it is important that as soon as we have mapped it out, if you will, or figured out exactly the placement of the equipment and so forth, how it's going to happen, that we share that with them and give them the opportunity to come in and take a look and communicate with us about it. And then secondly, I think it's important that everyone understand that the procedures to be followed on the recount are prescribed by the state. Like, I already saw this memo that the Department of State sent out that said if you have the HART equipment, this is the procedure to recount it, meaning, as Mr. Allen explained, if essentially the ballots that were counted in the precinct now have to be centrally counted, and the ballots, the mail ballots, and the absentee ballots that were centrally counted now have to be counted by a different method, either by these different high-speed scanners or by the precinct scanners. And as you know, many of the folks here I know have spent time in the precincts. I think we are wise to attempt to get a high-speed scanner, because it's 5 or 6 seconds for each page once it's actually in the scanner to go through the front and the back, and you can do the math for 35,000. That's going to be a lot of time. So if we can get these high-speed scanners on a loan basis or a rental basis or whatever it is, I think we should pursue that, because it would be able to be done in a day or so, as opposed to it's going to...
We were on the phone with the voting equipment vendor last night and again this morning. So we jumped on that right away.
And the state does reimburse us at least partial costs for the recount.
Well, that question did come up in the conference call. The state reimburses the counties essentially under the older law, $50 per ballot box. I inquired whether by ballot box that includes, now with the advent of Act 77, every container that we use for vote by mail, as well as the drop boxes, and they indicated they believe so. So we're going to try to get as much reimbursement as possible from the state, because there have been closer contests that fell in this 0.5% window statewide in recent years, where the candidate who was apparently in second place did not ask for. So this is a rather large margin, but it's still within that 0.5%. And because the candidate did not waive the recount, it automatically becomes mandatory.
Yeah, I mean, I know that in the past, some candidates have said, I'm going to waive it because I know this is going to cost the state, you know, millions of dollars, whatever the math is, to $50 a ballot box for every ballot box in the state. But in any event, well, that's where we are on that. Unless anybody on the board has anything further, perhaps we can go to the next item, which is, oh, and I apologize, Crystal, I did say you were first, you're second. The next item is the absentee envelopes.
So there were 65 absentee envelopes that we received back that were all within 6 precincts. This, we had a plan for this before there was litigation filed Friday, was it the 29th of October? And we presented that plan for handling these issues to the court, and the court included in the court order resulting from that litigation our instructions or our processes for reviewing these 65 envelopes that were returned, where the outer envelope had the correct name and address. And this was a manual insert issue at the wharf. And the return envelope, though, had, they got out of sync and they placed another voter's return envelope. So because we knew the precincts where this was involved and the mailing where it was involved out of the wharf, we were able to, you know, isolate where these instances occurred. In each of the 65 that you have before you, the recommendations are to count the ballots. We made sure also that none of these voters voted in person, that none of these voters voted a provisional ballot. We verified that one did cast a provisional ballot, but it was a no count decision by voter registration. So that means we do count this vote by mail ballot that was properly tendered. These also went through, these also went through more scrutiny than any other vote by mail envelope, than all other vote by mail envelopes, you know, this and the earlier group that you approved at Tuesday's meeting, in that all the signatures were verified, and all of them, I can tell you I have extreme confidence that these signatures are legitimate, and if you wanted to review them, we have them in the building, sealed, but they are available.
So, as was pointed out to us the other day, sometimes we talk about things at a level that not everyone can understand. So I want to make sure that we are very clear about this. In instances affecting, I think it's 6 different precincts, persons in our office whose job it was to take the ballots and the return envelopes and insert them into the mailing envelope for absentee ballots made a mistake. And when they were doing, for instance, the first 13 of these are Upper Providence 1, within that universe of Upper Providence 1, they mismatched the insert to the envelopes. So for these 13 voters in Upper Providence 1, they got their ballot in the mail, but unfortunately the inside of the envelope was not their ballot. It was another ballot for one of their other neighbors in Upper Providence 1. So the effect of this for these 13 people is they all live in Upper Providence 1. They all got an Upper Providence 1 ballot, but the return envelope that they got did not have their name on it. It had somebody else's name on it. And they nevertheless voted these ballots and returned them. Some other people that this happened to within these same precincts, they exchanged their ballot or they surrendered their ballot. They didn't vote the ballot, but for this group of people, they voted the ballot. The ballot they voted was a proper ballot for their precinct, but the return envelope did not have their name on it when it came back to us. And what we did was we looked at those, in this instance, these 13 from Upper Providence 1. We looked at the signatures. We matched them up to the voters identified on the list in Upper Providence 1, and it's their signatures, and we made a determination that for these 13 people, they may have returned a ballot that was not in an envelope that had their name on it, but it was nevertheless a ballot for Upper Providence 1, that they would otherwise have been entitled to vote. And they voted that ballot and returned that ballot to us. So the recommendation is for all of these groups, because the persons did vote the proper ballot for their precinct, the ballot they would ordinarily been entitled to vote as an absentee ballot, we should count these. The only difference was it was the return envelope that we mistakenly sent them was not their return envelope, it was a return envelope for someone else within this group. So again, on the theory that these voters did nothing wrong, that it was a mistake that we made in the Board of Elections and sent an improperly addressed envelope, still the right ballot, still the ballot they were supposed to vote, that we should count the ballots. And we've determined that these persons on this list, these 65, did not otherwise vote. They didn't vote twice. They didn't vote by surrender. They didn't vote by provisional. They cast these ballots. They thought they had done everything, and but for our error, they would have been able to.
I want to point out, we did this extra procedure whether the name matched. So within here, per the court's order, we promised to review all of the items from this absentee mailing for these 6 precincts. And some of these individuals, in fact, did come to the courthouse, the Voter Service Center, and say, I received the wrong envelope. So when we were checking those, they voted actually on their own envelope. So,
I see. So this does include some of the ones that were exchanged. Okay.
Exactly.
I didn't realize that. I thought the ones that were exchanged were already counted. But so this does include some of the ones that were exchanged. All right. So that's the issue. Maybe we can get a motion to put this on the table and we can discuss it, and we'll listen to the comment if there is any.
I move to count the 65 ballots on this list presented by the election director.
Second the motion.
So moved and seconded. There's a motion to count these ballots. Let's do it the way we did it the other day. We'll hear from the public first. I can see there's some lawyers out here who may educate us. Mr. Pupio, would you like to go first, sir? This is Michael Pupio from Springfield Township.
Thank you. Good afternoon, members of the Election Board, Mr. Allen and Mr. Martin. On this comment, I am appearing in my behalf as attorney for Mr. Agavino and Mr. Lombardo in the matter that was filed earlier. Mr. Lawrence, I know that you had, Chairman Lawrence, excuse me, I know you had provided the explanation for those for what exactly happened, but I would submit to you that the ballots that I had indicated and were referenced in the court order would qualify as challenged absentee ballots under the law if I were to need to appeal this further. I have not had the opportunity to review those ballots. I have not had the opportunity to see those ballots, and I believe, and I've requested, respectfully requested to do so, and respectfully requested to understand the procedure, and that has not been granted. So I would say.
But I think I want to get to this point right away.
Sure.
I saw you did make a request, but it was at noon, more or less, at some point earlier today, a couple hours ago. Was there a request before that
Yes,
that
sir.
we screwed up?
Yes, sir, there was. There was an earlier one, and again.
These were available in the media office when you were downstairs and you came in and reviewed along with.
Provisionals.
No,
I
in
reviewed
in the bureau office and media the other day before the Tuesday meeting. These also were there.
Yes. Yes, they were. Excuse me. They
Sorry.
were there.
And they were available for viewing
Yes.
at that time.
My question, though, for Mr. Allen, respectfully, I just want to understand one of the things that Mr. Lawrence had stated, and I just want to understand so I can move on with questioning, that these ballots that you believe the ballot contained inside the secrecy envelope for voter A, who received voter B's ballot, is the correct ballot for voter A.
Yes.
But you don't know that until you open that ballot.
No, actually, it's printed on the return envelope, and you know which, the return envelope indicates which ballot style was provided with that envelope.
So the return envelope with an incorrect address and barcode underneath it contains some indication as to what ballot is in there?
Yes, it does. It says, for example, Upper Providence 1 or Radnor 6-1 or Radnor 6-2 or Radnor 7-1 or Radnor 7-2.
But, you know, Jim, I hear what you're saying. I think Mr. Pupi might be making a different point. You know, certainly the return envelope indicates the form of ballot that should be inside the return envelope. But I think your point, Mr. Pupio, is we don't know if there could have been an additional mistake that we don't know about.
Correct.
Where there would be a different ballot in there than is what's indicated on the outside.
Correct.
You know, that may be a possibility, that there could have been a further error made. We don't know that. And we won't know that till we open them, which is why we're here today, to vote to open.
Technically, that's true of all 145,000, or rather 45,000 that are mailed out because of the construct of the secrecy envelope. So once you separate the secrecy envelope, I don't know how you go back and...
So my suggestion for this court, or for this board, is to hold an in-camera review, which is the process that you would do, that is not a process that's open to the public, to invalidate the secrecy aspect of these. But I would submit to you that while I respect the explanations provided by Mr. Allen, both here and in court on that Saturday, I really do not understand with specificity what processes were engaged. How did you, A, determine it was only 65 ballots? I recall an initial inquiry with Mr. McBlain about the topic, and again, I don't want to get too far afield as to who said what and when, but a response was, it's only 6 or 8 of these.
That was a week before.
And almost my entire reason for initiating the case was, did I get the only 2 or 3 of the 6 or 8? I mean, could that have happened, that somebody just reached out to me with those? You know, so I struggle to understand the scope of the problem. So now I struggle to understand exactly how we're going to determine whether the ballot was the ballot inside a secrecy envelope with an incorrect name and return barcode is the actual ballot for that ward and precinct. Okay. So I believe there's another review that needs to take place, an in-camera review on those specific ballots to determine that. And additionally, I would like to inquire more about what was the process determined. So 65 is an odd number. Was it 65?
Well, 65 is how many were returned. Of course it can be an odd number.
Okay. But of that 65 return, that leaves someone that may or may not have voted a ballot that we're not aware of. So it's not just 4 ballots where we can identify 1, 2, 3, 4, and I got yours, you got mine, John got Jerry's, and Jerry's got John's. You answer the question. Here's the 4 mix-up. So a 5th person could not have either voted incorrectly or voted at a polling place.
Yes, they could have. They could have taken the envelope and the ballot that they received to their polling place or to the voter service center.
Okay.
Let me offer this. I seem to, I think, you know, that the main concern you have is to look at the first one, you know, how do we know that that is actually Upper Providence 1? Because just because it says Upper Providence 1, it's foreseeable there could have been some additional mistake. And we know one mistake was already made, perhaps another additional mistake. And I guess the onus is how to slice that envelope open and make sure it's Upper Providence 1. And you know, perhaps the thing to do is that when our people slice them open, that they confirm that it is indeed Upper Providence 1. Now, I understand your next statement's going to be, no, I want to be there as a watcher and observer, and I can tell you I have a hesitancy with that right away because the sanctity of the vote is really important, and to some voters it's of paramount importance. So
well, this matter is, I'll close my conversations on this matter indicating that I object to this board counting those. I would indicate that they are the subject of of litigation. My request to this board would to agree to an in-camera review in front of Judge Eckel, who retained jurisdictions over those ballots, in order to determine the appropriateness of that. That protects the secrecy of the ballots, and we can move from there. In the event this board declines that indication, I would respectfully request that those ballots not be counted at this point and not intermixed until I have the ability to seek judicial relief on the topic.
Mr. Chairman and board members, this was exactly the request that was made and denied in the court.
Yeah, I think this, Mr. Pupio, one, I'm not so sure that Judge Eccles is willing to do the in-camera review, so I'm not going to direct her to do anything. So perhaps if we proceed this way, it may not be what you want, but it may be acceptable. Perhaps if we consider the matter and take a vote today, but say that we won't do anything for 48 hours with those ballots, give you opportunity to ask Judge Eckel to review it and ask her if she wants to do an in-camera review, and obviously we're going to follow the court's direction if she says you have to open them in our chambers as opposed to opening them in the Board of Elections. Would that be
Thank you, Mr. Chairman. That'd be satisfactory.
All right.
Can I ask a question?
Yes.
So if, let's pretend Upper Providence 1 got Upper Providence 2's ballot, under your hypothetical. Then there would be many votes on that ballot that would count.
There'd be a partial count.
Correct.
I
So
concur.
Is it possible then to, without having to conduct the in-camera review at all, to recognize that if it's designated as an Upper Providence 1 ballot, that it be treated, whether through this, in the way we treat those partial counts, as a Upper Providence 1, and if they have any mistakes on the ballot, then it's just a partial count. I don't know whether it would have to be.
I think we would proceed that way, and I don't want to put Mr. Pupio in a position to have to say I don't trust you, but if I was in Mr. Pupio's shoes and I had a client, I would want to make sure that there's
I
some
understand.
there's some second set of eyes on those things to protect my client's interests. So I understand what he wants to do, and I think that's reasonable. And if the court wants to direct that it be done in such a way that there's a second set of eyes, that's fine. If the court denies that relief, then we'll do it the way we traditionally do it, okay?
Thank you. That would be my comments on the matter with regard to the absentees. Thank you kindly.
A couple questions first for Mr. Allen, Mr. Chairman. Mr. Allen, I'm just trying to straighten out in my mind, maybe I misunderstood a couple things, but this is 65 that were returned to us with a different outer envelope than the voter's name.
In most cases. These are 65 that were definitely part of that absentee mailing.
And was there a larger universe of absentee ballots, in it, more than the 65 that were sent in incorrect envelopes, but then the ones that aren't these 65 corrected it before it got to us? Did that question make any sense to you?
I think the answer to the question is yes, because I think what we're saying here is, and Mr. Allen, you'll have the number. We know the mistake was made on a particular day, so we've looked at everything that was mailed on that day, and of all those mailed on that day, we got these 65 back. Is that a fair way to say it?
That is.
Okay. So in other words, there wasn't 200 and we remailed 200.
No.
And okay. And just to, like I said, I'm a little dense sometimes, just to make sure I'll ask the same questions I did regarding the mail-ins. So we checked to make sure that these 65 people didn't cast another absentee ballot, didn't do a mail-in ballot, didn't vote in person on a machine, and didn't vote provisional, with the exception of one person whose the recommendation is not to count the provisional ballot.
That is correct.
Okay. And then just, if I could offer comments, Mr. Chairman, my inclination would be to vote to approve these, but recognizing the issue that got brought up, just sort of spitball, my recommendation might be that if, when we do that, we notify the people that were involved with the litigation, that they can be observers of the process where they're removed from the envelope, and our staff is then going to determine, that, voter number 1 was Upper Providence 1, and we're going to make sure it's an Upper Providence 1 ballot in there, and that, say, if it's an Upper Providence 2 ballot, then it gets put to the side. And so
John, I agree that that is a very reasonable way to proceed. The only hiccup I have with that is having outside observers there, and to the extent that that could potentially compromise the secrecy of the ballot. And I guess it could be done in such a way that you slide the top out and you see what it is, but
But aren't
I see
watchers,
it as a slippery slope.
aren't watchers permitted to be present when absentees are,
A little less directed focus on the fact that they're pulling it out, looking at the top label, they could see the votes that start to fall underneath that.
But theoretically, when the normal absentees are counted, there's 100 of them are just opened and put aside, and then they're actually examined. They're not examined as they come out of the envelope. By the time you're actually looking at the ballots, they're separated from the.
well, correct. So here, it wouldn't be that they would open it, run it through the machine, you know, and certainly I'm not saying that the observer would be standing over or close enough that they'd be able to see, you know, who was there. I mean, again, I don't know where the election staff plans on doing this, but, you know, if somebody was sitting at a table and somebody else was sitting in a chair far enough away, they'd say, okay, I'm opening number 1, it's Upper Providence 1, there is an Upper Providence 1 ballot in there, you know, and they put it down, and
Well, maybe if
Well, these already are sorted, just so you know, by precinct, and so we can do one batch at a time, knowing that these are all Upper Prov 1.
No, I understand, and certainly, you know, we could get the 13 from Upper Prov 1 in a pile, and it would be very easy to check that those 13 are all Upper Prov 1. But, but what might be relevant is the third one might be one's wrong and the rest are all right. So it almost has to be done individually.
But why does that matter if we don't count, if we do a partial count on that one? If we know that it's an Upper Providence 1, that's what my original question was. Why does that matter?
What I'm suggesting to the board is that if we process them separately in 6 different batches, then we can open the envelopes and stack up the 12 or 13 or 8 that are from that precinct. And then, once, you know, they're entirely separated, and there's no, you know, risk of invalid or violating the secrecy, then we can make sure that however many are there from Upper Prov 1 are all Upper Prov 1, and then we can transcribe everything but, for example, the vote for judge of election or inspector in that precinct.
And this isn't a crazy idea. That's how it used to be done. We used to sit at the polls when they would close, and we'd count our absentee ballots in exactly that way.
I just want to make sure that Mr. Pupio's concern is, if that satisfies your concern, I'm fine to do it that way, but I thought your concern was more of, if there's one that's not right, you want to know whose it is that isn't right.
But why?
Well, I guess but why? If there's no but why, then...
I do not wish to know the identity of any voter here at all. The identity of the voter and the choices that they make.
If you don't think your client would have objection, and you don't have to say for sure now, right? Because I'm going to give you time to decide if you want to appeal before we do this. I'm not going to do it this afternoon. But if you're fine with this process of, we open the 13 from Upper Providence 1, and then you can examine the ballots in a stack before we count them to make sure they're all Upper Providence 1, and that's your concern about having an observer, I don't see a problem with that.
That procedure, I don't need to leave to come back to you. That procedure would be acceptable, sir.
Okay. So then we'll as part of the motion, in the event that we do vote to count these, then set forth that the motion will be to count these 65 and to count them in such a way that each precinct is separately opened, that the ballots are shuffled, and then the observers have an opportunity to inspect the ballots to confirm they're each from that precinct, or if they're partial counts, where they're from, and then we can proceed to count them with that procedure, okay?
And before he wants to speak, but I just want to amend the motion then. So move to amend the motion.
I'll second the
For
amendment.
the record's clear, and I think Mr. Wygan would like to.
Okay.
Larry Wiegand, Marcus Hook 2. So your entire conversation, I'm sure, is incredibly confusing for those that just tune in. It's confusing to me. I'm kind of struggling on why we're having such a position on the secrecy. Do we have enough employees that we could have one group unveil the secrecy to verify that these ballots are where they're supposed to be from, and then another group that would be able to actually unveil the ballot and then count it?
Oh, yes, sir. It's not our concern to do that. It was our concern that the objectors would want to watch, what part of the process they would want to watch. We're not concerned with the staff being able to properly separate the ballots. It was whether or not a watcher could be there while they were separating them to actually see whose ballot was whose. But if we're going to have the watchers at a distance, and then the watchers will only closely examine the ballots once they're separated, the secrecy concern goes away. It's the watchers impeding on the secrecy, not the staff.
And if I may, this is the old procedure when absentee ballots used to be counted so it's the same procedure. It's just being done centralized.
Well aware, being someone that has been in there, is that not something that couldn't be done, of saying, you know the precincts that they're from already, why couldn't the respective boards from those precincts be contacted to be present then? They would have done it in years past. Is there guidance from Act 77 that tells us what to do here? Or are we making this up as we go along?
Well,
No, we're not making this up as we go along. This is pursuant to,
Kind of figured.
this is pursuant to procedures that we presented to the court, and the court incorporated in a court order. So we're following very strict procedures so that even if it's a very clear instance of the voter receiving his or her own envelope and signing his or her own envelope, because we agreed in court to watch for any from these precincts, we still pulled those aside. We still followed the signature verification requirements, and these all check out.
And I understood from your comments, you're confident in all of that.
Yes, sir.
So what specifically does Act 77 state for the procedure when we have this type of a faltering?
Act 77 does not prescribe for the extra steps that we followed per the court order. Okay. So we're actually going above and beyond what Act 77 requires. Act 77 requires us to verify that this envelope was mailed out, and it relates to this election, and there's no requirement to check the signature or anything like that. So we're actually going above that requirement, given these circumstances, to make sure that we're balanced between not letting anyone vote more than once and also not disenfranchising anyone through something that was not caused by them.
Can I make a comment? Sure. I think one of your questions was, why doesn't the local board do it? Act 77 centralized this now. Again, we could have a, I would not have voted for that provision. I like the idea of them being, counted at the local places, but that's not the way it is, so that's there now. And Act 77 does not have a provision that says, if we get it wrong and we send it in the wrong envelope, this is what you do. But this was the process that was discussed in court, and is being discussed here today in front of the public. That's the whole idea of trying to come to some process to handle it.
I understand, and I'm fairly reasonable. My next thing to all of you, Mr. Allen, and the board is, okay, you have this problem and you're going to decide what you're going to do with it. What policies and procedures are you guys going to put into place moving forward here so that this doesn't happen again?
Mr. Chairman, could I suggest that the public comment here is narrowed to the question of whether these should be accepted?
I'll answer this
That's
question.
a more appropriate comment for the end of the
That's a good point. We're just trying to stay on focus, but...
Sorry, Mr. Chairman, if I'm jumping ahead.
This mailing of the absentee ballots is the same process that has taken place in our office for 75 years. And it's, somebody has to get the list and stuff the envelopes, and they made a mistake. And we have a process about how they do it, and there's checks, and it was a mistake this time. And, other than and it's, the same persons we've had doing these processes for a long time. And we're going to ask people to be careful, but, the other day you asked a similar kind of tough question about how can you keep somebody from making a mistake? Like we we have a process. We have a process where the work is checked, and this slipped through the process. And, you know, we have to look at that process and see, is there a better way to do it? It's the same way we've done it for a really long time, and it hadn't happened before. It certainly hadn't happened on this scale. And, you know, probably did happen once or twice before, but it was never brought to our attention and a big deal made about it because it wasn't on this scale. And we're going to just have to redouble our efforts and be better. That's all there is to say.
Understand. The volumes are drastically different today than they were in yesteryear, though.
Part of it, too.
Like, Mr. Allen.
Thank you.
Okay, thank you.
All right. Are we ready for any final discussion and a vote here?
Nothing more discussion.
Yeah, okay.
All right, unless there's no discussion, we'll call the question. All those in favor of the motion say aye. Aye. Any opposed? No one's opposed. All right. Do we want to delay actually counting these to perhaps Tuesday morning in case anybody wants to appeal?
I would strongly recommend against that because we're due to certify the election on the 18th. For us to certify the election on
We
the
need the
18th,
3
we have to
days, yeah.
conclude all voting or vote counting tabulation.
When do we propose to count them then, Mr. Allen?
Tomorrow.
I thought, Mr. Papia, you indicated that that procedure was acceptable. Is that sort of a partial withdrawal, assuming?
Well, my understanding of the procedures was whenever this was going to take place, once the secrecy ballots were there, I would be able to take a look at them to verify they are in the right pile, precinct, ward type of stuff.
That's what we're doing.
Tomorrow. Just let me know what time and where.
Very good.
Please.
All right. So Mr. Allen will communicate that to you with specificity, but probably tomorrow morning. All right. Next item is again Mr. Allen and Ms. Winterbottom. We're going to deal with the objections to the provisional ballots. So I'll begin by saying, for those of you who aren't familiar with this, so provisional ballots, there is a procedure. The code requires us to, within 7 days of the election, examine each ballot envelope that's received to determine if the ballot's entitled to vote at the election in that district. There's watchers. We complied with that. We did that last Monday. Representatives are permitted to keep a list of who casts a provisional ballot and to challenge determining whether or not the ballot was properly cast and counted. So Ms. Winterbottom undertook that on Monday, and she'll give you the exact number, but with about 1,500 ballots. Determined about 1,200 of those were appropriate to be counted. 137, she'll give the exact number, will not be. Of the 1,200 that were determined appropriate to be counted because the voter was eligible to cast a ballot, there were objections to 37 of them. And the objections, we're going to go through them one by one. We'll go through them by group. We'll consider each of a similar type in order. And the objections are of a technical nature. They weren't signed in the right place. They weren't dated, et cetera, et cetera. So we're only here today on the 37. The objections deadline has passed, so there are 37 objections. Those we have to decide. The other 1,200 are to be counted. And with that, Ms. Winterbottom, you prepared a list. You gave us all copies of the cover sheets. So the first 8 persons on this list, and we'll discuss the first ballot first, and then the other 7 in that first group. They are all no signature in box 2, which is no signature for the affidavit. I think the board is pretty clear that if you don't sign the affidavit, your ballot doesn't count. So with that said, that's the issue with the first one, Thomas Rush, correct?
They did not sign box 2. Box 4 is the affidavit.
I thought 2 was the affidavit. What am I looking at wrong?
Who's the,
Yeah,
who's the affidavit?
Who's the affidavit?
I think that the whole-
I'm sorry, I might have said affidavit, but I remember last general 2020, box 4 had to be signed when the voter handed back in the ballot and everything signed with the secrecy and sealed it.
Right. But for this one, for the first one, Mr. Rush, Thomas Rush.
Did not sign box 2,
Did not sign
correct.
box 2, the affidavit. So I think the law is pretty clear. If you don't sign the affidavit, we can't count that ballot. I'll ask, is Mr. Rush here? Does he have any representation here? No, okay, so.
Yes.
Yes, oh, you know what, I meant to say that as part of the introduction. So the code requires that for each ballot that's marked challenged, that we give notice to the voter. We gave these 37 persons notice of the hearing today. I'm guessing there's a couple faces out there I don't recognize them. One or two you might be voters. And they can come here today to be heard, which is why I'm asking if Mr. Rush is here. And he's not. So with respect to Mr. Rush's ballot, is there a motion?
Are we going to do all the ones with the same issue?
Well, I was thinking we do him, and then we just do the next ones
Okay.
as a group once we see how we're going to vote, because we'll
Okay,
presumably vote the same.
all right, we're moving on. How do you want to phrase the motion? Count it or not count?
Is there a
Give me your
motion not to count Mr. Rush's ballot?
So moved.
Second.
All those in favor, say aye. Any discussion?
I have a question. I just
Yes.
want to make sure. Ms. Winterbottom, this entire fixture is on the outside of the provisional, right? This is an incomplete page.
Yes, that's a copy of what we have here. It's a little larger than regular size paper, so a little bit might be cut off.
And as was indicated, I think by your initial hesitation about the affidavit, is that this section 2 is considered the affidavit portion of that page.
Yes, I checked with Manley on this when we started reviewing, and it was my understanding, that's why we had marked it as a full count, what we thought
This is
the
why I'm
review
asking
should,
these questions,
because he wrote me that was correct, that 4 had to be signed.
He said that 4 had to be signed.
I think actually it's the opposite, so I think 4 does not have to be signed.
And that's why our recommendation was full count. Originally, you'll see that middle column. So if that's what's determined, we will then no count that.
And if Mr. Martin, I don't know if
Mr. Chairman, I think that given the circumstances of the current envelope and the affidavit, I think that there is an argument to be made that if there is a signature of the voter on the outside of the envelope, whether it's in spot 2 or spot 4, that the board would be justified in finding that the requirements of the code have been satisfied, and that there is evidence per the signature that the voter signed for and voted the provisional ballot, and to stand on the technicality of whether there are 2 signatures or if there's only 1 signature, whether it's on the left side or the right side, I don't believe is absolutely required by the code and by recent interpretation of the law.
And I also,
See,
sorry, go ahead.
I just want to be clear here. There's that Allegheny County case from last year, Commonwealth Court case in Allegheny County. My understanding, and it seems to be what it says here in this memo, is that provisional ballot must have a signed affidavit in order to be counted. In that case, rejected attempt to count ballots where a signature satisfying both requirements. Therefore, the provisional ballot does not contain both the signed affidavit and the signature on the front of the ballot envelope cannot be counted. However, because our ballot has the voter's signature also on the front of the ballot, that is a technical matter. In Delaware County, if you sign an affidavit, you're signing the front of the envelope, that the affidavit signature should count for both, but if you don't have an affidavit signature, we can't count it. That was my understanding, and maybe I'm wrong.
Mr. Chairman, I have prepared argument on specifically these items that may provide you with clarification as you move through with items 2 and 4, and I can make that and submit that, and it could be considered that argument, and I believe it's a point of clarification for this board.
All right, we'll hear it before we take a vote. We'll hear the public comment. But
My other question is, I can't remember precisely, but if you, Ms. Winterbottom, or Mr. Allen, or Mr. Martin know, this is not the first time we've seen this question. I was just curious as to how
We
we
had
resolved it.
a lot in the general 2020, and if I remember correctly, I think it was determined that the last one, when the voter hands in the ballot, had to be signed.
The
Box 4.
box 4 was the box.
That's what I believe was decided last year. And I know some things might have changed this year with the Allegheny case that you were referring to.
And the only reason I ask that is because I remember that because, I mean, box 4 is the one that has the big old giant X, and it's bolded and says sign here.
Correct.
So, okay, sorry, that was my question.
All right, let's hear the public comment, and then we'll get the source for the rule. And I'm going to vote whatever the source for the rule is, I'll tell you right now. Okay.
So I respectfully disagree with Mr. Martin and whatever, any written objections that, or any written direction that Mr. Parks may have made. And I would like to hand to Mr. Martin and the board. I'm not sure
It's caught out right.
This is the Ziccarelli case, which is directly on point for this. And it also...
All right, this is the case I'm talking
Yeah,
about.
this is
This is the case I'm talking about, right.
I would also hand you the code for us to refer to, and what I'm handing you is the copy, the front page is the code, the second page is section 12, and then the specific section is 1210. I also have so I also have to you how we treat and review an opinion that is from the Commonwealth Court as to how that goes. So when we have a case like this from Commonwealth Court that's unreported, I am permitted to, in any filings or any cites, directly use this as evidence that my argument is persuasive, but not that it is binding. This is exactly the same case that we had. And if I can run through Ziccarelli, Ziccarelli had two cases, or Zaccarelli, however it's pronounced. The first was a challenge to undated or lack of a handwritten address on absentee or mail-in ballots. And this case, which was a separate action detailing the error in completion of box 2 or box 4 for us, and I'll run through that very quickly. The case with regard to mail-in ballots and absentee ballots was consolidated with the Trump case that detailed that these things, at this point, that there are some minor aspects and there are some major aspects, and that dating it was not necessarily one. That's the case that said that. But that did not compare provisions of the law. You can distinguish this case very clearly, and this case that is in front of you does it, when they very succinctly say, we don't have to get to that tortured analysis, even though we did that. We had to do that in the case with absentees because the new law did not provide a remedy for what happens if it is not counted. So if I can have one of the forms, Crystal, do we have a form? Here it is. So the forms that you have in front of you, I think that Ms. Lunkenheimer just questioned, okay? So if you will follow box 2 is box 2 is the section of the statute that is 24 or A4-2 provides that with the quotation marks. The statute indicates that section, prior to voting the provisional ballot, the elector shall be required to sign an affidavit stating the elector's name, date of birth, blah, 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 and that it's the only ballot that they cast. That's box 2. That's consistent, the language matches. Box 3 is, or excuse me, box 4 is set forth with the language that the court advised that after the provisional ballot has been cast, the individual shall place it in the secrecy envelope. The individual shall place the secrecy envelope in the provisional ballot, shall place his signature on the front of the ballot. You know, this court held that A, the statute, the language was unambiguous, and you can compare that to the exact statutes that I held. And they did hold that although our decision may be perceived as disenfranchising voters, the election code mandates that these deficient ballots shall not be counted. This court emphasized its following and faithfully applying the mandates of the General Assembly and our Supreme Court. Accordingly, the plain language of the election code and a lack of evidence in support of the position advanced in this case was that election personnel improperly instructed people out there. There is nothing along those lines that has been alleged here, at least to this point, and even if it is alleged, this board would have to weigh those. So I would submit to you that it is clear that any lack of a signature in box 2 or box 4 is facially invalid. And therefore, even though this provision, these have been challenged, but it's facially invalid, that this board, the challenge stands, and this board shall not count. Going further in that statute, which I will talk about a little bit more.
Can I ask you a question about that?
Yes.
And I'm really just trying to make sure I understand.
Yes.
So here, I think the thought that was presented to us in part that we want to consider is that we got one sort of page on the outside of the envelope, right?
Mm-hmm.
Okay, so whereas other jurisdictions, I don't remember what this jurisdiction had. But they basically say, as I read it just a little bit on the fly, right, as we're talking through it, we have looked at this before, but that both signatures are required. And you said, and sorry, not you, the court says in this case that there's the signature that's required by the affidavit with the name, date of birth, address, and testing that the ballot's the only one they cast, right? Which I think, are we in agreement that Section 2 satisfies, at least in terms of what it requires?
Yes, I would say the statute that we referenced in, I think, A2, or
Right.
whatever that is, whichever that statute that provides the language for it is box 2.
Right, and it complies. It appears to comply, which it's not.
The language, my research and review of this is that this language is the exact language in the statute that is required to be signed. Whether it's address, city, zip code, municipality, any of that stuff I think is arguable, but the affidavit is correct, word for word, and that it's required to be signed. So my argument would be anyone that does not have a signature just on the answer to your question on vote 2, pursuant to this case, is facially invalid.
Okay, and then also I think you're making a further argument, and that's the one I want to push on just to make sure I understand it, is then it goes on to say you have to put the envelope in the secrecy envelope in the provisional ballot envelope, and the elector shall place his or her signature on the front of the provisional ballot envelope. Would the fact that a signature on box 2 would inherently be on the front of a provisional envelope because of the way we practice here, does that mean that you don't actually need a signature in box 4? What you really need under your argument and under this case is you need a signature on number 2, because that signature double counts. It satisfies that second requirement of being on the face of the provisional ballot envelope.
My argument would be no, that it does not, only because it specifically sets forth, Section 3 of the order, Section A4(3) indicates after the provisional ballot has been cast, which in my opinion means the elector fills out their ballot. The individual shall place it in a secrecy envelope, in the provisional ballot envelope, and shall place his signature on the front of the provisional envelope. All provisional ballots shall remain sealed in the provisional ballot envelopes for return to the County Board of Elections. So
You're saying timing-wise, it can't happen both ways.
That's correct. You have to sign 2 before you sign 4. And this case holds that both 2 and 4 are required. And the distinguishing aspect between the PA Trump case is that there was no language in a statute that said, what should we do? And in this objection procedure, as we go down, as you go down and understand what has to be reviewed, you get to 5A, you get to 5 under this, and 5 starts out with, except as provided in subclause 2. Subclause 2 says, a provisional ballot shall not be counted if either the provisional ballot envelope under clause 3 or the affidavit under clause 2 is not signed by the individual. Both are required. It's set forth in the statute. I raised my hand to make this argument because I believe it is determinative of any issues in box 2 and box 4 where a signature has not been placed. That's why I raised my hand and went to jump up out of place.
In your argument, Mr. Pupio, shouldn't 5, 2 little I, A, it says or, it doesn't say and. So it doesn't say they both have to be, it says one of the two. Statutory construction, shouldn't it really say and if they both had to be signed?
I don't know. I tend to think we're going to, I tend to think as we discuss, as happens in any of our practices, when laws change, this provisional ballot law for elections is relatively new, 5, 6, 7 years, I believe. You know, it's going to change and we're going to make some law on it. I think the case that you have in front of you answered the question of and or. And I don't believe, I believe that the reasoning set forth by the judge in that case, by Judge McCullough, is persuasive. Not binding because of the rules that were there, but I believe it's persuasive. I believe it answers your question.
All right, thank you. Mr. Solicitor, what's your advice?
I think Mr. Pupio accurately articulated the significance of a not reported decision from the Commonwealth Court. And, you know, he accurately described the position articulated by the 2 judges. You know, the dissenting opinion focused on the significance to be provided to protecting the franchise and not disadvantaging the voter because of inadvertent technical errors. I would say, nonetheless, I think that not to prejudge future items on this list of 37, but I do think he has convinced me of the requirement for the signature under number 2, though I think in cases where we have that signature at number 2 on the envelope, the subsequent absence on number 4, I think should not cause the board to reject those votes. So I think that if there's not a signature on 2, based on this decision and based on the law, it is better not to count it.
Thank you, sir. I tell you, I came in here thinking the same thing. I mean, that's how I had read and interpreted the law on my own. So thank you, Mr. Pupio. Are we ready to vote then on...
I do want to make a couple comments. I did look at it. Mr. Parks had provided the board a memorandum for guidance, and he cited the same case that Mr. Pupio cited. So I think everybody agrees that one case applies. If you read that case, it's unmistakable. The court says that the voter has to vote in both places. The voter is attesting to different things in both of those signatures. It's not just mere surplusage. The Commonwealth Court, looked at it and said it has to be both. If you read the statute disqualifies it if either you don't sign in one place or you don't sign in the other place. So I don't think there's an and or involved. It's either or, and it's statutorily very clear. The fact that Delaware County, I don't know what other jurisdictions use, but the fact that we have it all on one page to sign, I looked at the statute again after I read Mr. Manley's memorandum.
Mr. Parks.
Mr. Parks.
That's a common thing. A lot of people don't use
I'm
that.
sorry, Mr. Parks's memorandum, and I don't think it makes a difference whether it's on one page or the other. It doesn't say that, one's got to be enclosed within the other. It doesn't read like that at all. It says the voter has to sign the affidavit prior to getting the ballot, and then after marking his ballot, the voter's got to sign something else. And just to sort of, hearken what I've said in previous meetings, I think the role of the board, is that if there's a clear statutory provision that tells us, what to do, I think we have to follow that. You have to follow the rules that are laid down. One of the commenters, today said something, are you making it up as you go along? No, we don't do that. We may, where the statute is not clear, such as if a mistake is made on these absentees, we use our equitable powers to try to do that. But when the statute is clear, and here we have a Commonwealth Court interpreting that statute, telling us what to do, then I think that's clear that there's got to be both signatures. So my intent as we go through today, whether we do it as a group or one at a time, would be that if there is not a signature on both box 2 and box 4, then I will vote not to count that provisional ballot.
Okay.
I'm comfortable on the 2 one. I'm still want to
Yeah.
talk about the 4, but I think for the purposes of the current motion, I'm comfortable that 2 does need to be signed.
Okay, so let's then consider items 1 through 9. First of all, let me just ask it this way. Are there any voters here who have come to defend their ballot? What's your name, sir? I'm sorry? Xander.
He's 29.
Number 29, all right. Are there any other voters here? Okay, so there's no one here then on numbers 1 to 9, and I would propose numbers 1 to 9 are all no signature.
8. Nothing to, oh, no.
Yeah, 9 is the same, yeah. 10 is a little different. 10 is no signature in it, but 1 to 9 are all the same, no signature in box 2. So if we could have a motion to not count ballots 1 through 9, which are Rush, Miller, Kelly, Williams, Garino, Hospodar. That is Eddie Hospodar from the Flyers, by the way, riding a 3-1. I know that's where he lives. Restiano, Mancini, and Marks.
And I think did we move the first originally, so we're amending the last motion to as to number 1 to include the first 9?
Yes.
Then so moved.
Second.
Okay, so the motion then made and seconded is no count on numbers 1 through 9, the persons identified. All those in favor of not counting 1 through 9 say aye.
Aye.
All right, so 1 through 9 are out. So we're at 10, Ms. Winterbottom, if you want to go back to the podium.
Well, 10 doesn't have a 2 either.
So 10,
Mark, please.
Ms. Ware's ballot has no signatures at all. So let's have a motion on 10 kind of stands by itself. A motion to not count number 10, Ms. Ware's ballot not signed in either place.
So moved.
Second.
Any discussion? All those in favor of not counting number 10, Ms. Ware, say aye.
Aye.
That motion carries. Now, number 11. That's a little bit out of order. Number 11. So number 11, we'll do number 11 by itself as well. Number 11 is just like 1 to 9. Number 11 is not signed in box 2, although it is signed in box 4. So can we have a motion on number 11,
So moved.
Nancy Skinner, to not count?
So moved.
Yes.
Second?
Second.
So the motion made and seconded on Ms. Skinner's ballot, number 11. Any discussion? Seeing none, we'll call the question. All those in favor of not counting Ms. Skinner's ballot, say aye.
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 Aye. That
Next
motion
two look
passes.
similar too.
Next to no signatures at all, right? No, sorry.
This one, the voter signed above the box.
Yeah, but they didn't sign in number 2, so,
Neither one signed at number 2, right? The next two? Yeah.
so 12, 13. All right, so 12 and 13, both are unsigned in box 2, the affidavit. So if we could have a motion for a no count on number 12, which is Mr. Butera, and a no count on number 13, which is Mr. Gugassian.
So moved. Oh, sorry.
Second.
So moved and seconded, a no count on 12 and 13. Any discussion? Seeing none, we'll call the question. All those in favor of not counting numbers 12 and 13, say aye.
Aye.
All right, now, we get to number 14, and it looks like 14, let's check 20.
Oh, 14 itself has a different deficiency, it looks like, in addition. In that they didn't fill out the affidavit.
And they also signed above on number 4, and they signed 2.
Yeah, that's,
So,
well,
but
let's
the
do
address
14
is,
by itself.
yeah.
So 14, I understand the objection is, it's not signed in box 4. Actually,
Kind of.
let's put 14
Okay,
aside for a
that sounds
minute,
good.
because 14 is a whole different problem about the affidavit being filled out. Well, we should handle that differently. I think we can get rid of a lot of these. If we look at 15. 15 through
Yeah, that's a
19.
true did not sign number 4.
Yeah, so 15 through 19 is not signed number 4. 20, the only objection on 20 is no signature in number 4, correct, Ms. Winterbottom?
Number 20 was from the file 4 list. The 708 list.
Oh. So we,
For
so
number
the
4, I
voter in
can
number
withdraw-
20,
Excuse me, for number 20, I can withdraw the objection.
so number 20 is withdrawn, no objection. So then,
Can I, not to complicate things, but since it, does that mean that, and Mr. Allen, would this person, if it was a file,
that's what, yeah,
get myself confused.
did number 20, Ms. Benoit, did she have a vote count in the file 4 votes? Because we don't want her to vote twice.
Since there were 412, I don't have all 412 committed to memory. I apologize. But
Well, let's
I
do
can
this.
go downstairs and
Let's just do it this way. If we take no action on this, there's no objection right now, it's been withdrawn. So if we take no action, before this is counted, Ms. Winterbottom's going to check and see if she otherwise voted. And if
Yes.
she's otherwise voted, it won't count, and if she hasn't voted, it will count, okay? So 20
So that- we'll
would
put
take
that
no
downstairs
action on
if
for
she
the objection
voted.
to withdraw.
Excuse me, Mr. Chairman.
Yes, sir.
Question on that. So, as I'm going to comment at the conclusion of the meeting on the procedure for provisional, the recommendation for number 20 was no count. So, if I withdraw my objection to that, my understanding is that's a no count.
right.
Correct.
So
That's a
I
no
withdraw
count.
my objection. I don't believe
Gotcha.
you need to
No,
go any
okay,
further.
you're right, because if
It
it's a,
doesn't matter.
if
So
it's
it's
a
a no
no, if it's a
count.
no count, then we should have counted
Right.
Well done.
the file 4 if it did arrive and we reviewed it.
So, 15, 21 is the same as 15. Trying to get all the ones that are
Yeah.
the same together. 22, we go to something else. 23, we go to something else. Okay, so let's then look at,
22 actually fits within the 1 through 9.
yeah, that's a different, yeah, that's why. Let's look at 15, 16, 17, 18, 19, and let's just do those. Okay? They're all did not sign number 4. And the recommendation is no count for these 1, 2, 3, 4, 5.
Yeah,
There-
Mr. Chairman, for number 18 and 19, I believe that we withdrew those, Crystal?
But you left them in the pile because they already got the letters.
Okay. That folks already got the letters. I withdraw those as well. I withdraw numbers 18 and 19 with the recommendation being no count.
Okay, those are withdrawn, those are no longer before us. So now we're with
18 and 19?
15, 16, 17. Recommendation is
No count.
no count because they're not signed in box 4. So the objection is seeking to have them counted. Based on what Mr. Martin said before, it would be the board's interpretation of the law that since these were signed on the face in box 2, although not signed in box 4, that these should be counted.
And that's why I'm struggling, that's what I want to,
Does anybody want to make a motion to get this underway?
oh, so moved.
So there's a
Are
motion,
we moving them to not,
a motion to sustain the objection and count 15, 16, and 17.
so moved?
I'll second just for purposes of voting.
Okay. Discussion.
I'll just say, as I stated before, I believe both signatures are required, so I'll vote against the motion.
I'm struggling, the solicitor has indicated that he disagrees with what you've just said, Mr. McBlain, and I just have some questions about that. I mean, certainly the dissent seems to disagree, that there's some technicality. I think Mr. Pupia makes a good argument about timing. It's impossibility, but and I think whatever comes out of this, Mr. Allen, again, I'm sure it was emphasized because this comes up every time, but in the training for the poll workers, the importance of trying to emphasize what might seem illogical, which is the double signature on the same sheet that sits next to each other, right?
It is, however, I have had conversations with Ms. Winterbottom about trying to redesign this form ahead of the May 2022 primary, precisely because I think the design, which I believe comes from a state vendor, right? It throws you off. It's got a nice prominent X on one section under the words voter signature, and then it has voter affidavit and a very tiny, like 8-point, I would guess, in terms of size and the font, voter signature X. It should be clear that they're either, that those should be bridged together or perhaps simply combined so that both the affidavit and the voter's declaration that they are an eligible voter or elector could be above one signature location. I think we ought to look into that with our solicitor, because right now this strikes me as kind of a trap door.
Yeah, I don't know that we have to solve this problem today, but I do wholeheartedly agree that sometime between now and the next election, if we don't have to use the state form and we can use a better designed form that's more clear, we should, because we have a lot of confusion, obviously, about these things. So, but on these three, 15, 16, and 17, do we have any other comment on the motion?
I just want, oh, sorry, go ahead. Oh, yeah.
Only other than my point that I believe 2 and 4 is required, and I do object to counting number 17. Thank you.
Yes, sir. 15, 16, and 17, you're objecting to
Great.
them all? Or just 17?
Just 17, sir.
Okay,
It's the only individual matter I represent.
okay. Are we ready to vote?
I just was seeking, I'm struggling with it and was seeking a little bit more about the solicitor's recommendation. I think that the argument may be that other than the temporal element, there seems to be a technicality. The statute requires the signature on the outside envelope and the signature on the affidavit, and the importance of the affidavit is obvious from the affidavit itself because it says, this is the only ballot I've cast, which creates a different level of importance, I think, than just a temporal issue. So it goes to the dissent, but I just would, Mr. Martin, if you have any other thoughts that could help me render a view, I would appreciate hearing them. I am struggling with this.
No, I think you've landed on the main distinction, and you know, in terms of the opinion, and again, which, you know, as we've noted, it's an unreported opinion. You know, the minority makes the point that there have been circumstances where, you know, the Supreme Court has looked at a place where, you know, the law talked about, you know, used the word shall in reference to black ink on ballots, and then subsequently determined that they were to accept green or red pens ink when it was clear what the voter's intent was. And I think that here it's clear from the facts we have in front of us that these individuals cast these votes and intended to comply with the law.
All right, so if we're
Thank
ready,
you.
we'll call the question. So the motion is to sustain the objection and count the ballots at 15, 16, and 17. All those in favor of counting 15, 16, and 17, say aye. Aye.
Aye.
Opposed?
Nay.
So 15, 16, 17
And what happened to 14?
will be counted. 14 we put aside because it has
Oh, right,
two
sorry.
problems, and I was trying to decide
That's
things
right,
that only
no, I
had
just
one
got lost
problem
in
before
my
we got to
notes.
two problems. But I think we're,
Well, then 21 fits the same question.
21 is a no count recommendation, and the objection is withdrawn.
21, objections withdrawn. Twenty-two is a no signature on the affidavit in box 2. So can we have a motion to not count 22, which is Mr. Patton's ballot?
So moved.
Second.
Any discussion? Seeing none, we'll call the question. All those in favor of sustaining the objection and recommending a no count on number 22, say aye.
Aye.
That motion carries. Number 22 is a no count. All right, now we're on number 23, which my list says it's an incomplete affidavit.
Looks like the most filled out form we've seen.
Yeah, so, Ms. Winterbottom, what's going on with 23? It looks pretty good to me.
This was challenged by Jared Laird. I'm not sure why it was challenged. I'm thinking maybe in box 3, kind of looked maybe scribbled.
All right, is Mr. Laird here today?
This was that one.
Yes, he is.
Oh, I see him now, I'm sorry, somebody was standing in front of you.
Withdraw the objection, sir.
23, withdrawn. 24, incomplete affidavit.
Yeah, if you want to see it.
Why don't we look at this one too, Mr. Popio? This one.
I believe this is the same issue for 3.
Not sure what it is.
Is that the address of the voter?
Yep, so here's the print screen.
Number withdrawn, sir.
23, withdrawn. I'm sorry, 24 that was, Mr. Sylvester, that's withdrawn. Number 25, Thomas Orner, and my list says, same thing, incomplete affidavit.
Same thing. Upper Chi 41, registered, Upper Chi 41, 106 Village. And I think it's because of number 3.
Withdrawn.
25, Warner is withdrawn. 26 is already withdrawn. 27, Charlotte Warner. Wasn't a good day for that house.
I believe this is one of the same issues.
Withdrawn.
27 withdrawn. 28 is Ms. Crilly's ballot. Again, incomplete.
I think it's number 3. June.
Same argument, it's same position, withdrawn.
Withdrawn. 29, Mr. Zander, you are here, sir. This is your ballot. You can come forward if you want.
For the same issue then.
29.
Actually, he has everything filled out.
I'm guessing you might not need to say anything, sir.
Yeah.
Let's see where we go with this.
That's what Jared had wrote, but.
I would withdraw the objection. I don't
Let's
know
just let Mr. Zander know the
actual
outcome.
objection, but with the voter here, I would withdraw that.
Yeah. All right, so Mr. Zander, the objection to your ballot has been withdrawn, and I thank you, sir, not only for voting, but for taking the time to come down here today to defend your franchise. Thank you very much, sir.
Thank you.
Number 30, Mr. Patel.
I believe same issue for number 3.
No, we,
Signature issue here, it says.
this was a signature issue.
Here we go.
I believe that it's the same signature.
You do?
I do.
Withdraw.
Yeah, I mean, we have it here, it looks pretty close, I'm not an expert, but withdrawn.
Signature does not match I mean, they look pretty close to,
Yeah, I think on the next page, John, is the
oh, the registration.
Yeah.
registration.
Oh, okay.
And the
Still
P's
looks
done the
pretty
same,
close. I
the
mean,
H's
it's
done
not-
the same.
I would withdraw that.
Thank you.
And, you know, in fairness to Mr. Laird, you know, the signature cards, they're scans from PennDOT, and they're difficult sometimes, but that looks pretty close. Okay, 31.
This was someone that had a different name and a different address and just did not change it in time for the election. I did speak with them on the phone about this hearing coming up and that their provisional was challenged. They just asked how they can update their name and address. We believe it's the same signature because of
Yeah, it's pretty
This-
distinctive.
the first
The
name.
middle initial look identical, I agree on the signature. The last name's obviously a different last name. But the first half of the signature looks,
This was also a partial count because they were registered in Ridley 3-2
right.
and voted in Ridley 8-1.
All right, let's have a motion on this one. So there's an objection. It was a partial count, so the objection would be to the partial count. So the motion would be to,
Not count.
boy, I've been doing this for
Dismiss the objection.
too long today, to dismiss the objection and count the ballot.
So moved.
Second.
Any discussion on this one? We'll call it. All those in favor of counting Ms. Ameloth's ballot, say aye.
Aye.
Aye. All right, so 31 is a count. 32, Ms. Diorio. Says, oh, no secrecy envelope. All right, let's check the rolls on that.
This person I spoke to on the phone, they are out of town, and they did tell me on the phone that this was all that they were given when they went to the polling place and didn't know about a secrecy envelope.
Okay. Is Mr. Paul here, or Mr. Paul is your client, Mr. Pupio?
It is not. I have no interest in this.
I think it's on- yeah.
So is Mr. Paul here? All right. So I guess then the objection, so it was a no count, and the objection was then to overrule the no count and to have it counted. So
And then we had spoke to the voter to let her know that the hearing was today. So our initial review, because there was no secrecy, was a no count.
Right.
The observer had objected that and challenged that, and then letting her know, she had explained that she was only given the affidavit and the ballot.
Okay, so what would be in order then is a motion to sustain the objection and count the ballot for Ms. Diono.
So moved.
Second, for purposes of the...
Yeah.
Right.
Now, I understand this is a little bit of hearsay testimony, but the hearsay rule doesn't apply here, so I'm going to consider the testimony that the voter wasn't given the right materials, and my inclination is to accept this ballot, but we're open for discussion.
Well, I'll note that the code does say a provisional, it should not be kind of a provisional ballot envelope does not contain a secrecy envelope, if I'm going to be consistent.
No, and
You know,
I agree with you.
But I hope I lose the vote.
All right, and I agree with you, Mr. McBlain, but there's other case law that says where it is the fault of the Board of Elections for not providing the right material to the voter, that we should count the ballot. So I'm inclined to count on that. Does anybody else have?
I'm inclined to count, but I can't, how was the motion worded again?
So
Say aye or nay.
so it was a no count, there was an objection, so the motion is to sustain the objection and count the
Count the
ballot.
vote, okay. I'm ready to vote.
And it's been made and seconded. Is there any further discussion? Seeing none, we'll call the question. All those in favor of counting Ms. Diorio, number 32, say aye.
Aye.
All those opposed?
No.
All right, so her vote counts. 33.
It has no section 2 signatures, nothing in section 2.
33, this one's straightforward. This is Ms. Maratea. There's no affidavit and no signature in the affidavit in box 2. So, and it was already a no count.
Upon further review, there's actually nothing in this affidavit.
Yeah, right, there's no
Right.
affidavit at all. So it was a no count. The objection was to overrule the decision not to count it and to count it. So let's make the motion to overrule the objection and leave the ballot as a no count for Ms. Marita.
So moved.
Second.
Any discussion? Seeing none, all those in favor of not counting Ms. Marita's ballot, say aye.
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 Aye. All right. Number 34. So this is
Yes.
a objection to
This is
the voter does not live in Radnor 7-1.
Oh, boy.
So 1062 Lancaster Avenue, 519. Is that in 7-1? I think it
Yes.
is.
Our records indicate that the objection is ours, and the information that I have from Data Center is that this individual moved and resides at 400 Steel Road, Havertown, PA 19083. And therefore, if this individual were to have voted, they should have received a Havertown ballot rather than a Radnor ballot. And at best, it should be a partial count with those offices for which the individual resides. And I can hand up this data, it's just a printout.
I think she indicated on the upper right corner that she lives at the Steel Road, Haverford. Is that right?
Yeah.
So I don't think she was trying to hide anything.
We have Ms. Sill registered at 1062 East Lancaster, which is in Radnor 7-1.
Well, what's the, let me just ask Mr. Pupio, you can hand it up in a minute, but before you hand it up, what is it that you have
It's
there?
a printout from voter data center, GOP, that indicates that the individual has moved, and it listed the.
Does it say when she
I mean, I
moved?
accept that as being likely to be true,
Yeah,
right?
does it say when she moved? Is there any evidence of when she moved?
That was
Sarah, does it say that? It does not say when.
All right, so we don't know if she moved within 30 days of the election and she'd be eligible to vote anyway. So, all right, so,
So my argument and objection would be that that would be a partial count for only those offices that she could vote for, which would be statewide and county, right down the Register of Wills would be the last one. That she would vote for, that would be my objection. So I would object that it should be a partial count
Okay, so when I do this, we'll frame the motion as there's been an objection that it should be a partial count. So the motion would be to reduce the ballot to a partial count from a full count. So let's get a motion out there so we can have a vote.
So moved.
So moved. Second?
Second.
So moved and seconded. I will say this, I think it is pretty clear that as of Election Day, certainly she admits on her form that she lives in Haverford, so obviously no issue with a partial count. But at the same time, I don't see any evidence of when she moved, and if she moved within 30 days of the election, she's allowed to vote at the original address. So I'm hesitant to disenfranchise her without any evidence at all when she moved.
Is there any, Ms. Winterbaum, did you have any contact, or is there any additional evidence?
We left a message about this hearing on November 10th,
Okay.
but did not hear back from her.
Any further discussion on this one, number 34, Ms. Sill?
No, I would, it's clear she moved, but I would tend to agree with Chairman. Without evidence that it was, outside, I actually thought it was longer than 30 days you had, that you could come back to your
Well,
old polling
you
place.
no doubt have 30 days. There's arguments that you can vote for up to 6 months.
Yeah, that's what I thought it
But
was.
there's not even an argument about 30 days. You can't change your address in 30 days. So,
Right.
in any event,
So our motion was for a partial count or for a full?
the motion was to sustain the objection and make a partial count. So if you want to counter vote, you can vote no. So all those in favor of reducing this from a full count to a partial count, say aye. Hearing none. All those opposed to the motion, say nay. Nay.
No.
All right,
Okay.
that objection is overruled, and she remains a full count. Adam Williamson, number
Does not live here.
35.
Registered Lowry.
Voter does not live in the district.
That's that.
So
Same
this-
argument, sir. Same printout, same partial count argument. This person identified that they're there, and the only aspect is, as maybe you consider back, this is the opportunity for that voter to come to you and indicate that they do live where they're registered. And both for, I understand you, I don't want to cause problems and ask you to revisit both of those. But from
I
an
understand
objection
your
standpoint, I am going to, I would appeal both of these on the same ground. So I believe the voter, at a minimum, had to come here today and explain to you where they live versus at least the evidence that is on here that their current address is 756 Buck Lane, and the hand up that I would also indicate to you that it is a secondary address that is recognized on this printout, and therefore it should be a partial vote, sir.
And I just, this is going to be, I grew up a block from Buck Lane. This is really not in the district because we were in Delaware County when I grew up.
Oh, no, this is...
No, it's in Delaware County.
Oh, okay.
This is in
Oh,
Radnor
this is
Second
exactly-
Ward.
oh,
County
it's-
just-
The note says not in district, okay.
No,
We
Buck
don't
Lane's
need
going to be
district.
in
I'm
four-
not magisterial.
four
district.
something, yeah,
Okay.
that's in Haverford 4. So in any event, I understand. So this was a full count. The objection is to it being a full count and have it be a partial count. So the motion is to sustain the objection and partial count this ballot. I'm kind of in the same place I was on the last one. I mean, on the face of this, yeah, he admits that he's in Buck Lane, Haverford. He says that, but we don't know when he moved, and the voter showed up, and presumably he's eligible to vote, and showing up where he's eligible to vote and voting. And I'm not going to disenfranchise him without evidence that he didn't do that. So without any evidence of the timing of when he moved to this other address, I'm going to oppose the motion.
Yeah, can I ask, Mr. Chairman, just because the copy that we have, I see where it's 756 Buck Lane, but it just says address is different than section 2. Maybe Ms. Winterbaum, can we see that? I don't know what it says above that.
Do you have a full form that's, like our photocopy's kind of cut off? Yeah.
Current address in box 3?
He wants to see the top of.
Oh, he's giving.
Box
Yep,
three.
no, she gave me what I need to say.
So people can see.
To the top of box three.
Mr. McBlain is looking at the original, just the photocopy we have kind of cut off the first quarter inch of the top of the page. No, I'm
No,
fine.
I know I'm gonna, thank you.
Maybe, again, I don't know, this is more future planning and not directly the question, but maybe when we look at the form, we ask that question, but it doesn't mean anything, it's like, okay.
Yeah.
You know, you
So when we process the provisional ballot, the letter will go to the mailing address, which would be the Buck Lane address on this one.
I know, but presumably that means he lives at Buck Lane, but he knows he's still registered at Lowry's Lane.
But would have to fill out a voter registration application to change his address.
Right, that he hasn't done that.
And he could have moved within those 30 days, and then the 2-week last day to register also.
Maybe we can add a line to that section 3 that says, when did you move, or something like that, so that the judge of election knows, you know, if he wrote 1984, then presumably the judge of election says, well, you can't vote here, but it's not your fault, but it's like, it's a good question, and he answered it honestly, but it doesn't mean anything, because it doesn't really give us the information we need, you know.
Does our letter, when we do that, say, goes to a different address, say, hey, you should register in the right?
On the provisional ballot letter, it's generated, they're already in from the state, and it does say if you need to update any information, you can visit the website.
Thank you.
All right, Mr.
And again,
Pupio,
just
did
for
you?
record purposes, I believe that just in terms of the rules of evidence, even though they don't specifically apply here, you know, the voter was notified, and that the evidence that we have here indicates that in both of those cases that they do have a current address, and actually mailing them the information that their provisional ballot has been accepted to the address where they currently reside. I do understand it leaves the question open of when did they move and when didn't they move, and I would indicate that you're not disenfranchising them with a partial count. So again, same objections for the two of those, just from an evidentiary standpoint. Thank you.
Understood, and to the extent there's an appeal, I want the record to be clear here that, you know, the objector has the burden, and, you know, the burden of establishing that they're ineligible to vote. And without that key piece of information about when they moved, I don't feel that burden is met.
And
Mr. Allen.
Just as an aside, in addition to trying to reshape this form, we ought to consider, under the Help America Vote Act, that something like this can be used as the basis to update the registration and then send the voter a card in addition to a letter stating whatever the outcome of their provisional ballot is. And I don't know that we'll ever get to the point where we can tell the judges all the minutia of, you know, the date of when they moved, but we can use that information to determine whether to count it in full or count it partly. You know, so.
All right, so back to the motion at hand is a motion to sustain the objection and transfer Mr. Williams's ballot from a full count to a partial count. So a vote yes would be to reduce it from a full count to a partial count. A vote no would be to overrule the objection and leave it as a full count. All those in favor of the motion to reduce his vote, say aye. Hearing none, all those opposed say nay.
Nay.
Nay. So that motion is denied, and that ballot remains a full count. Next is 36, which is Mr. Capella.
So the signature for number 4 is next to the word voter signature instead of the X, but it still is one, there is one in number 4.
Oh, jeez. Okay, so 34 was determined by the board to be a no count, and the reason being that there is no signature in box 4. The affidavit is signed in box 2. All the other information is filled out. The addresses are consistent. The sole issue is there's not a signature in box 4 because the signature is next to number 4 and not in the box. It's about an inch from where it's supposed to be. There's 2 signatures. It's not in the box. So the motion is to sustain the objection and overrule the no count and have Mr. Capella be a counted ballot.
So moved.
Second.
So motion moved and seconded. Discussion.
Yeah, I don't know if it's come up or it's made a difference. And Mr. Martin may know this, does it make a difference that he hasn't filled out he hasn't printed his name or dated it? I accept that he signed it, he just signed it in the wrong place, but there's no other information like, he hasn't put down and,
Well, I know that the case law and the date isn't necessary because it's not specific in the statute, and I think there's a holding somewhere that says obviously it was signed on election day because the judge
Right.
of elections got on election day and signed on election day that the person appeared before him. So I think the date is kind of irrelevant. I don't know if there's any,
well-
the printing of the name, that the name isn't printed.
I think
And just so the public knows, the name is printed elsewhere, but it's not printed under the line in which you're supposed to sign because he didn't sign on the right line.
he signed next to the words voter signature,
Right.
and then apparently wrote, put an X.
I think that was probably the judge of elections, because they also probably thought that box 4 was the one. And they put for box
It says
1,
voter signature is a bold line, right? So you're saying
Right.
that they were trying to show the voter where to sign even if it was wrong?
Oh, I see what you're
that's
saying.
what I
Yeah, that
believe.
looks like somebody might have put that
So,
X there to show
I mean,
where
I
it's
mean,
signed.
I just looked at the statute, Mr. Chairman. I'm so sorry. It just talks about it should not be included if there's not a signature. It doesn't talk about filling in the, printing the name and that sort of thing, so I'm all right with that.
All right, so we'll call the question. All those in favor of the motion to sustain the objection and count Mr. Capella's ballot, say aye.
Aye.
Any opposed? So that motion passes. 36 Capella's counted. 37, Ms. LaRoe, no count / voted. So she voted in person?
No, her mail-in ballot was received. If you check the print screen from Shore, the last voted date also reflects that.
Okay, so we did receive her mail-in and count it. So the motion would be to sustain the objection and count this. So if you're going to vote, wow, this is such a triple negative. So if you're going to,
Well, wait, so, Ms. Winterbottom, so your recommendation is not to count it because you voted?
Yes.
Right.
so the objection is to count it,
Which would be a double vote.
which would be a double vote. So I got a feeling we're going to vote no on this, but
Right.
let's make the
So,
motion.
I'm sorry, she voted where? I'm sorry.
A mail-in ballot was received.
Which
So
takes
there are
precedent.
times when voters
The mail-in votes.
fear that they mailed it in perhaps too late to arrive, or they check the Shore system and it's not showing up as having been received. So they use the provisional ballot as a backstop. In this case, the voter's ballot was received, and the provisional ballot should not be counted.
I'm amazed we don't have more of these. We had a lot of those last time because of the Sure system is slow to update.
Right.
Correct.
Yeah,
So who wrote mail-in ballot not received by media? Was that the voter?
the judge probably. Look at the pen.
Yep.
Yes, no, the judge.
The judge.
Probably the judge. It looks like the judge is writing for the signature, but, not us. Not the
So
board.
we did get her mail-in ballot, and it was timely, so she voted that way. So we're voting to,
I'm voting no to sustain the objection that asks for it to be counted.
right, so we're dismissing the objection, right?
Yes. So all those in favor of dismissing the objection, say aye.
Aye.
Aye. So that is an N for a no count on my list. All right, that leaves the one we skipped, number 14. So 14's got a lot going on.
Yeah, and the address is there, it's just in the wrong place.
So 14 is Mr. Waterland, and Mr. Waterland signed the affidavit but did not fill out his address under the affidavit section. Does have his address in box 3, and then in box 4, much like Mr. Capella, signed next to the word voter signature and did not sign in the actual box. So this has a whole bunch of things we looked at already today.
And he's got, he states that he lives at a different address.
But he doesn't. He's registered at the address that he states.
Okay.
I think he just made a
This
lot of
this
mistakes.
speaks to the problem with the form.
Yes, we're all in agreement.
Yeah, he's registered to vote at 5 Cross Creek Lane, and it says on the form, enter your address if different than enter the address you live at if different than the address at which you're voting, and he enters 5 Cross.
He could have gone left and right, though. He could have gone left to right. And,
Which is
yeah, it's his address.
where he voted, and he voted in in Concord 1, right? And this is a ballot for Concord 1, yeah. So he
Gonna let
voted in
gonna
his
let kids from
precinct.
Alden out in Concord in Chad's Ford, is Cobb's Creek Lane and Chad's Ford in Concord?
Yeah.
If you look at the registration at the bottom left side, it indicates Concord Township, and then the 13 stands for Concord, and then the 1 is which precinct it is, so.
I mean, despite the procedural errors, it seems to me that this voter tried pretty darn hard and filled out the the bare minimum is they have their address, that's in the wrong place, they have their signature in both places, just on the upper line instead of the other line.
And the objection, is this one of yours, Mr. Pupio? This is Mr. Paul. All right, so, and Mr. Paul was established is not here, but his objection is he didn't sign in box 4. He didn't actually object to the other part about the address not being in the affidavit, so that's not before us. It's only about signed next to voter signature and didn't sign in box 4, which we've already looked at that issue and said,
I don't even agree with the
The form itself
objection.
is fairly confusing there. He signed it in 2 places. It's outside the box. It's next to where it says voter signature, as opposed to in the box where he's supposed to put the voter signatures.
Well, the objection says should be counted,
Right.
and we had originally no count.
Oh, I'm sorry, I misunderstood.
So we should, you could consider sustaining the objection here and counting it.
I'm
And I'm
sorry,
inclined
I
to
didn't
do
look
that.
at that. You're right. So it was a no count, so the objection then would be to count the ballot. So the motion would be to sustain the objection and count Mr. Wardoin's ballot. Is there a motion?
So moved.
Second.
Any further discussion? So we'll call the question. All those in favor of sustaining the objection and counting Mr. Wardoin's ballot, say aye.
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 That one's counted. That might be my phone, sorry. All right, so we are done.
Thank you.
I guess we can compare notes if you have any questions, but I saw you taking diligent notes, both of you, and we have a videotape of it to look at, so we can go
Thank you.
back if there's any issues. All right.
Minutes are going to be hard.
Well, you know what, we can put the minutes as we decided the objections, and you can look at
That's
the
right.
video if you really need to go over them. Now, unfortunately, I put my agenda somewhere, here it is. Next is board member comments.
I don't think I have anything else at this point in time, Mr. Chairman.
No.
There being none, next is public comment. Is there additional public comment? Yes, sir, Mr. Pupio.
I do. I'll try to be quick because I know folks have other things to do, but I would like to walk you through what I believe to be a problem that exists in your procedure currently.
Okay?
So if I am, as we sit right now, you have before you, you have gone through 37 objections. Some were withdrawn, some weren't withdrawn. When an objection gets withdrawn, there was a determination that was made by the election personnel as to whether it should be counted or not counted, and then someone objects or does not object. I would submit to you that the case law and the recommendation from your solicitor, at a minimum, on items of number 2, they don't need to be objected to. They are facially invalid, and they are marked as that, regardless of whether it's a count or a not count. If there's a signature that is there on a provisional ballot that is lacking a signature in number 2, regardless of an objection, that's a facial, pursuant to that case law, that's a facial irregularity that needs to be remedied. And I would point to you the following, and I will just run through it quickly on the statute. If you turn to section 1210, which is the section that does this, you go down section 1210 to A1, which talks about how a voter may apply, and you get to A2, which tells them why they may be able to get a provisional ballot, and then you get to A4. A4 is the situation that we are in where a regular individual moves forward and casts the ballot. A41 sets forward that. A42 is the language that we discussed being relevant. A43 is the other box that we discussed it. A44 indicates that what has to happen. Within 7 days, the County Board of Elections shall examine each Board of Election. Now, I would submit to you that you haven't done that. I would submit to you that county personnel has done that and has then discussed it with you. But I don't know if there was a formal motion. I don't know if anything had happened there.
I understand where you're going with this, Mr. Pupio, but there's about 10,000 places in this code that says the County Board of Elections should do this, and it doesn't in each instance mean us, right? Because it says the County Board of
Well,
Elections should count the
I
ballots. We're not
accept that
opening every
I
mail-up
accept-
ballot in the 35,000 mail
Right.
ballots. And this is the same thing. The personnel is doing this at our direction.
Okay, I still believe it has to come before you. I still believe that you have to make a decision to count these provisional ballots that still remain.
We do that.
That is
at-
not
we-
on.
We do
is-
that, we do
right.
that at certification. We decide to count all the ballots, and we say, these are this is, we've completed our processes, and there is 63,000 ballots counted for A and 66,000 ballots counted for B. We don't actually physically count those 66,000
Okay.
ballots. We rely on the local
Well,
boards
if
of
you-
elections and the board personnel to make some of those counts.
So am I to understand that the provisional ballots are not included in a count that you certify until you say to count them? Because if I can just finish,
right,
if
go
I can
ahead.
just
I
finish what
probably
I
should have
have
interrupted you there, sir.
very quickly and walk it through, I believe you have a problem. I believe you have a significant inconsistency. And looking at that section, it tells you, and you appropriately made the point about you not being able to do everything. But it says, within 7 calendar days, County Board of Elections shall examine each provisional ballot that is received to determine if the individual voting that ballot was entitled to vote at the election district in the election. One authorized representative of each candidate in an election and one representative from each political party shall be permitted to remain in the room in which the determination is being made. So that says to me that, at least my interpretation of that, is whatever the face sheet that is required, that if we go down and indicate the election personnel, are you reviewing this, we were permitted to be in the room while that determination was made. That did not happen here.
That you weren't permitted, or that you just didn't go?
I would have to ask Ms. Winterbottom some of those things. I'm just pointing out to you what.
We give notice that we did it
Yeah.
last Monday at 9 a.m., and the public's welcome to attend, and if they attend, they attend.
I'm being technical. I respectfully disagree that is when you want to go and object. I respectfully believe that this requires participation and observation in the determination that the election board makes, not whether we object. And I would set forth that if you follow down here, 4 that we are on, A14, sets forth this procedure that we just went through today. Sets forth, first, what I say is that we should have been permitted in the room. I believe that those determinations, I'm not exactly sure where they took place. So I'm certainly going to ask that as to where they took place. Did they take place here or at the wharf?
Voter registration.
Okay, so they took place here, so they were taken from the wharf. The actual determination was made in voter registration. Public was not there. I would then submit to you.
Can I ask a question on that? Mm-hmm. Because I believe that during 2020, we did have people attend, right? And there was concern about making sure there was room, because it's the way it's set up. So just so you know, I don't think there's any intention to not perfectly avail people of the opportunity to attend, and that's why we notice it, and it would be available.
Sure.
And if there's any confusion about that, it would be available, I assume, in the next round of
Sure.
election.
I want to make clear, I'm making a legal argument here that I believe I have to do today. I am going to make one in court. These are new procedures, and as a victim of. We always used to do this, that when you come into a system, the bureaucracy of we always used to do this gets replaced with, are we following the law at times? This is a new procedure, certainly expanded by provisional ballots, and certainly causing that. So I believe that when you get to number 5 on this, number 5 tells you what you may and may not count, regardless of whether that petition was objected to. 5, except as provided in subclause 2, and 2 goes down, we had the discussion about A, either the provisional ballot under clause 3 or the affidavit is not signed. If either one is not signed, it is my position that it is a bad ballot. And then it goes down to, for example, what you have here, I would submit to you that I would bet that on your list of items that are before you to be counted or not counted, as determined by your voter registration folks as surrogates for the board, you get to number C, a provisional ballot does not contain a secrecy envelope. You would adhere to that. You know, you would adhere to that. I believe that everything that didn't have a no count secrecy envelope in those 1,300 remaining ballots is a no count. Somebody doesn't have to object to it. I believe your voter registration took those people right out because the machines can weigh them, we know, et cetera, et cetera. So you're doing that, but you are not doing item A. D doesn't apply, E doesn't apply. F you're doing, because if a provisional is made, but there is proof that the ballot got there, got at the wharf by 8 p.m., you know, that is registered as a no vote. And again, you know, F indicates that F3, one authorized representative of each candidate. My point to you is you have about 1,300 absentee ballots that are going to, 1,300 and a high number provisional ballots that have a recommendation from Ms. Winterbottom in the voter registration, or Ms. Winterbottom's staff in the voter registration office. And so some of them that you are going to count, if it have a no signature in number 2, which you just agreed shouldn't be counted. So I'm telling you, it is my position that that someone needs to go through those 1,400 and make sure they're a no count. You would be inconsistent treating voters differently in a disparate fashion if you didn't review the determination that is there. I submit to you that the determination of 2 or 4 would put all of them out. You know, my position that I will submit is that we should have an opportunity to see all those, to determine that. And regardless of making an objection or not making an objection, they're facially invalid. And if you agreed on some of the objection points today, at a minimum, anything that is listed as a number 2 should be out, that is there, should not be counted, regardless of the recommendation. And that would be my point.
All right,
So I think there's a procedural problem. I think it is somewhat significant. We have races that go, you know, we have races where people are ahead by 30 in some votes. It's unfortunately going to matter. So as we go through these procedures, one by one, probably in this election, you know, it's something I'm going to point out that I believe is an error. It's where we stand now. I believe counting those votes with an inability to pull them back is the equivalent of scrambling the eggs and not moving forward. So I would indicate at this meeting that I would object to, even though it's not on the agenda. I don't know when it is on the agenda. I believe it has to be on the agenda. Pursuant to this, that you have to approve the counting of absentee ballots. And I would submit to you that anything that is on that list that at a minimum has a missing number 2 doesn't count.
So as I understand what you said, really 2 things. One, that there should be some interim step before certification where the board votes on the counting of the absentee ballots.
The provisional, sir.
The provisional ballots. I'm
Provisional,
sorry, I said absentee, but you're 100% correct. I don't know that I read the statute the same way or that our solicitor does. The second point you made is, to the extent there, it was made clear today by the board that it's our position that ballots not signed in box 2 should not be counted. You think that there should be, before we count these ballots, we should double check them,
remove those
if
as-
you will, to double check that there's none included.
Yes, sir.
Without a signature in box 2.
Yes, I believe that item
I
4,
think just.
item 4 discusses the
understand.
procedure. 5 is separate, completely
Pupio,
separate from the objection.
I understand what you're saying. So I think that second point, that we make sure before we run these, that we are no count on anything not signed in box 2 is probably appropriate. Don't
I agree.
you guys agree?
I agree. I think maybe it was flipped, right? Ms. Winterbottom, did we not count 4s, but we counted 2s?
Today, that's what was decided.
It would be a
If
flipping.
2 was signed, right?
Yes.
Yes.
2 has to be signed for it to be counted. If there's any ballots where 2 isn't signed, we should not be counting those ballots.
I think as your staff went through it, it had it the other way.
Yes, that
Yeah,
is
the other way.
correct.
So do we have to also look at 4?
Yeah, Mr. Chairman, I agree. I mean, my position would be if either wasn't signed.
Yeah.
But I understand where the board stands on that. But
Yeah.
as he was speaking, that was.
Yeah, I mean, I think
coming-
since, the board's position is that 4 doesn't need to be signed, but I think we should go through these ballots and make sure that any ballot we're going to count is signed at number 2, and if it's not signed at number 2, it should be a no count on its face.
Did they revisit number 4?
Well, no, because we've already said if it's signed in 2, it doesn't have to be signed in 4. That's our position today, that if
But-
somebody signed at number 2,
They took the position as a,
not that, I'm talking about the board. So today we voted that any ballot, as long as it was signed in 2, was counted, even if it wasn't signed in 4. So,
but I believe then there are many that weren't signed in 4 that were not counted, that were signed in 2. Is that correct?
Say that again?
Is this the entire universe of ones that were signed?
So every provisional that went through my office also went through the observers outside.
I know, I understand, sorry.
So, no, these are only the ones that they objected to.
I understand.
so there's 132, I think is the number of provisional ballots that you didn't count, correct?
Yeah, around that,
Yeah,
I
we
can't
don't-
remember.
We can look it up, but perhaps you should also look at those.
Right. That's
I think there's going to be more in the full counts that will now be to no counts.
Correct,
Yes.
correct.
And my question, I guess my question, and I'm sorry if I'm not being clear, is did you not count some that had signatures in number 2 but didn't have signatures in number 4? Based on this, I would think that you did not count some.
After talking to Manley Parks on Monday before we started the review, it was my understanding that box 4 had to be signed, not 2.
Which means you did not count some.
That's how we reviewed it.
We want to make sure that we're consistent. So for the 132 that were not counted, review those.
Some of them are not signed in box. I mean, there's quite a few different reasons, but yes.
To the extent that the reason something's in that pile is because it was not signed in box 4, but it is signed in box 2, consistent with how the board voted today, those should be counted,
Got it.
okay?
And then the same for the ones in the full counts.
That are not signed in box 2, they should be not counted,
Understood.
okay?
Thank you. Sorry, it's more work.
Mr. Chairman, can I ask Mr. Pupio a question?
Yes, sir.
Mr. Pupio, your client objected to several because of the absence of a signature in number 2?
We did, and then depending upon the
No,
recommendation,
no, fine.
yes, some of those, yes. I'd have to have the list in front of me, but I will.
Did
I have
either
it.
your client or other observers working together with your client participate in observing, making an assessment of the entire universe?
I don't understand the question, Mr. Martin.
If your client was objecting when they saw no signature in number 2, or at least objecting to the universe of ballots that was of particular interest to them when they had no signature in number 2, do you have reason to think there's a whole nother set of ballots that didn't have signatures in number 2 that they didn't have an opportunity to object to?
I don't know. I asked that question yesterday and today. I just wanted to take a look at the ballots. I think I sent an email indicating that this wasn't the conversation I wished to have, but
Right, but
I believe you have a problem.
again, I'm just trying to understand the extent to which, and the board's decided what it's going to do, whether they're essentially double checking something that was already done or looking at something for the first instance. And my question is whether you think observers that you're representing were participating in a process looking for that missing signature in number 2, as would be suggested by the fact that they submitted this universe of objections for that reason.
And I don't have the answer to that question. I don't
Okay.
exactly know at this point, and
Yeah.
that's what I want to say.
But I understand the point that if, your observers were there, they looked at every ballot, they were objecting to some, and maybe they missed some, whatever, but this is a double check. And I just, our goal, as I said the other day, is we want to get it right. We want to make sure everybody's satisfied that we got it right. And if we can double check, as Ms. Winterbaum's going to do, to make sure that we did it right and did it consistently, I have no problem with double checking, because every problem we can avoid is one less problem that I have to go to court for.
Well,
Okay?
just one quick question. And this can be answered by either you or Ms. Winterbottom. Were the people who were there and filed objections that were timely targeting only specific precincts?
Or parties.
Some of them, yes.
I mean, the group, led by Mr. Laird there, were they, I'm not concerned with who answers this question, but weren't they targeting specific precincts?
Yes.
So they had the opportunity to file objections then on any precincts they wanted to, right?
Yes.
But they chose to focus only on certain precincts, right? So now today, you're saying that because the board ruled where it's yes, it's signed on 2, but no on 4, we want to have a whole new set of, if I understand this correctly, a whole new set of objections basically now? Or we're just saying
No, I don't think
we
that's
need to
what he
go
said
back
at
and
all.
reapply?
I'm saying that if you asked Mr. Laird, in my opinion, I haven't asked him this question, I think if you asked Mr. Larkin Jr. this question, they weren't exactly sure what an objection meant. Did an objection mean, were they objecting to counting the ballot, or were they objecting to the voter services position of counting or non-counting? Which is what I am saying is a step that I believe we missed, and we're at least entitled to be in the room when those recommendations were made. But nonetheless, you now have a list. You now have a list of these voters that you said no to number 2 on. And if there was no objection to ballot A in Dave Lang's MDJ race, and that person didn't check box 2, I submit to you that 1210A45 requires you not to count it.
Right.
It doesn't require me to object to it.
Right, and by
no
the same
count.
token, Mr. Chairman, if I may, there are some times where a judge of election, minority inspector, clerk makes a mistake, checks in the wrong vote or what have you, and there's no one who objects to it, and there's no, to use your words, unscrambling the egg. So it just strikes me that the objection period, the deadline occurred. This is akin to, let's say, people are objecting to candidates' petitions, and they show that certain ones are not registered where they claim to be on that petition, that candidate. And then after winning that objection, say, I want the board to go back and look at all the other petitions that weren't objected to. That's how this strikes me in terms of ordering us to do this.
It's not. A.44 sets forth the objection procedure. That's where it says you have to do this, you have to mark them
No, but
challenged.
you understand what I'm saying, though. If no one files an objection to that voter running for office, that voter can continue to, his or her name would appear on the ballot. There's no like,
Unless there's another procedure like number 5, which says you shall not count. Not I have to object before you count. You shall not count. You, not you, Mr. Allen. You, the board, shall not count. Shall not be counted if A, 3 and 4. That happens before an objection is made. Okay? That is an automatic facial defect that it says you shall not count. So you had some objections under 4 and all its subparts. We just did those. But under 5, it's not under the challenge section. It's under the you shall not count section, and it is, in my opinion, clause 2 and 4, as set forth in that case, is A and B. C is any ballot that doesn't contain a secrecy envelope. You do that. You make that call. It doesn't contain a secrecy envelope. I would, again, I don't have the discovery. I don't have the information, but I would assume that that is a no call on your, that the Board of Election, the Bureau of Registration goes through, sees no ballot, knows that's a no call. It doesn't need to be objected to. And I would then tell you that you also do, D and E don't apply because they're military ballots or ID issues. F under 5 is another thing that you don't count automatically. I don't have to object that my ballot was received by you and therefore the provisional ballot doesn't count. It tells you that automatically here. What I'm saying to you is right now, you have a list of 1,300 and some provisionals that do not comply with this section. If they have that, I believe it's inconsistent with that. I don't believe they should be counted at this point until a review of those is able to be done. If you do count them, it scrambles the egg. As Mr. Lawrence indicated, I would much rather not file. I will file on Monday because I think I need clarification.
okay, but
Enough. Now, let me explain what we've done and what we're going to do, okay? Ms. Winterbottom, as I understand the procedure, reviewed all these ballots for all of these items. She then put a face sheet on the front of the ballot that made her determination about whether or not that ballot would be counted. Then the watchers, the observers, whatever they're called, got the opportunity to look at her determination and object to it. So there's no opportunity for a second level of objection because she's made all these determinations, and after these determinations were made and her determinations were indicated, and she's making those determinations as us, right? She's doing this work on our behalf. The observers, the watchers have had their opportunity to make their objections. I understand you think it should be differently.
I do, but I just for record purposes, I understand,
That's how we
sir.
did it, and if you think it should be differently, I respect your right to think you should be differently, and you can go to court and be told it's different. That's the first issue. The second issue is, because it was made clear today that it's the intention of this board to not count any ballots where the affidavit in box 2 was not completed, we've asked Ms. Winterbottom to double check through these ballots before she counts any ballots for this issue. If box 2, the affidavit is not signed on any ballots that she's already determined to count, we're directing her to put those ballots aside and not count them, okay? If she's going to make any changes to any ballots, and we don't know that there are any, frankly, because I think this procedure we've had where she's looked at them, the watchers, the observers have looked at them and pointed out through their objections a number where she had said to count them, but they were asked by or directed by the watchers or flagged by the watchers that they shouldn't be counted. But if she comes up with any additional ballots that she had previously said were full count, and now she's determined they weren't signed in box 2, we're going to make that public, can have a chance to object to them if there are any, and we'll sort it out, okay?
Thanks, sir.
That's how we're going to proceed.
In public comment, Les, you indicated that you are going through the recount, that you have to for a statewide office. I am indicating here that I'm going to be filing a petition for a recount in 1 or 2 things. If there is an ability to work together along those lines in accomplishing that and only doing it one time, I'm certainly willing and able to discuss that, and quite possibly that recount might satisfy the concern. But I'd be willing to talk about it rather than understanding that you are going to have a statewide recount and you have certain data. I'm indicating to you publicly that I'm going to be filing for a couple of other recounts if you would like to discuss possibly doing that together so that efforts are consolidated and you are not doing things 3 and 4 times. I'd certainly be willing to discuss that. Thank you.
And I would appreciate that.
Is there any other public comment?
I just have a couple questions, if that's okay.
Yes, ma'am.
Are we going to have another election board meeting before certification?
We will have an election board meeting at certification on the 18th. Yes.
Oh, at certification.
Yeah, I don't anticipate having another meeting before that. If something comes up, we may, but as of now, we don't anticipate that.
Thank you. I appreciate your honesty. So my next question is, apparently there was some issues with envelopes and the vendor supplying a complete set of envelopes to given voters. Is that correct?
Well, we handled that on Tuesday, ma'am.
No, I know you did, but so I just want to understand a few things. I'm speaking for myself. I'm asking questions all on my own and without talking to people before I come here. So, because I got a few phone calls from voters that were saying to me that they didn't get the return envelopes in with their ballot. Just a few people.
So why don't you submit their names and addresses to Mr. Allen, and we'll investigate those.
Well, yeah, but I have some questions.
Okay.
That was not one of the problems that surfaced during
Yeah, I mean,
the
we're not
election
aware of that,
once.
but if
We
that's
did
the
not get any
problem, we'll-
calls or emails to that effect.
Oh, okay, so that wasn't one of the problems that you all heard about, was that some voters didn't get the proper amount of envelopes? Okay.
Once in a great while, we heard from a voter who did not receive a secrecy envelope, but it was like just a couple of phone calls, but that can be remedied simply by using, any plain envelope, any white envelope.
Oh, okay, great.
So
That's
but
good to know.
But as far as
I was
like,
wondering that.
yeah, but as far as return envelopes, no, we did not.
So it didn't have to be a specific type of envelope that was provided by your vendor, because if it wasn't, that they could substitute their own?
Correct.
Okay, good. The other thing I wanted to ask is, after the polls close on election night at 8 p.m., and at some point, you're going to begin counting votes, correct? And then you're going to be attributing those votes to whatever candidates got those votes, correct? And so those are going to show up on the website in the totals, where everybody goes to check to see how they're doing, right? Can I get a verbal on that?
Yes. I
Okay.
didn't know if there were more questions. I'm sorry.
So after the polls close and the counting begins, those totals for those candidates are either going to stay the same or go up, right?
Yes.
Can I have a verbal on that?
Yes.
Can I have a verbal on that from the board?
I don't know, I
This is- what
understand
is
your
this?
question.
It's a comment period.
It's a very simple question.
What's the question?
The question is, after the polls close at 8 p.m. and you begin counting the votes, the totals we see on the website, they're either going to stay the same or they're going to go up, right?
Which totals? The vote totals?
As we count, additional votes will be added if they're counted to
vote
and allocated to a
totals.
particular vote.
Okay, yeah, maybe, I'm sorry, it just,
They're either going to stay the same or go up, right?
If a new vote comes in, it'll go up, and if no
as
vote.
the vote
it'll
comes
stay
in,
the
it goes up? Exactly, yes.
Yeah, and If a vote doesn't come in for that candidate after the polls close, then it's not going to move. It's going to stay the same, right?
Well,
Yeah.
I mean, we're counting mail ballots.
Right.
We're counting V-chips when they come in. Eventually, then we're adding in provisional ballots. We're adding in
Right.
Uwakava ballots.
So you're adding votes to those totals, correct? You're not subtracting votes from those totals, you're adding votes to those totals,
Adding.
right? Can I get a verbal on
Yes.
that?
Mr. Sill, this isn't your deposition here. If you
No, I'm
if you have a
asking-
point, you can make your point, but we've been going on
I'm
and on
just
here.
asking a question. It's a simple
We've
question.
answered the question 4 or 5 times now. Is there
So
another
the
question?
total shouldn't be going down and then up and then down and then up. It should either be staying the same or going up, right?
Presumably, yes. Now,
Presumably. So what reasons would there be for a vote total after the polls close? And when you start counting mail-in ballots, can you just list for me reasons why you would see a candidate's vote totals bounce down?
I don't know why I would see that. I didn't see that, so I can't answer.
I'm just saying, is there any reason why a total would go down in number as opposed to staying the same or just going up?
Well, right here today, we just made a decision.
Right.
No, that's not what I'm talking about. I'm talking about from November 2nd to Friday,
Are you alleging that this happened?
November
Are
5th,
you alleging that this happened?
perhaps.
Well, what does perhaps mean? Did it happen or it didn't?
I will determine whether to, what if anything, I'm going to do about it.
Okay.
I just want to know
If
from
you're
you.
aware of some inconsistencies with the reporting of the vote totals, you should
Okay,
please
so,
report those to us with specificity
so
so we
sir,
can
I
investigate
saw my
them.
total bounce down and up and down and up. I saw my total drop 1,200 votes on November 3rd, real fast. The total showed at midnight on November 2nd, it was 59,818. Then it went down to 58,6 something
59,818.
during the day on November 3rd. And then it went up and up and up. Then it went down again. 3 times I watched my total bounce down. And it was between November 2nd, so Wednesday was the 3rd, Thursday was the 4th, Friday was the 5th. And I'm not the only person that saw that. I'm not watching other people's totals, I'm watching my own. I personally don't know, or I don't really think I won, but this particular point bothers me.
So here's what I'd like you to do, because if this happened, it would be bothersome to me too. Can you send us a list in writing of, because you had these numbers and you said them at different times, it was this and that, with the specifics of this, and we will investigate it, and we will have the district attorney's office investigate this, because I'm not familiar that this happened, but if you believe that it happened,
I
want to
saw
get
it,
to the bottom.
it's not a belief.
Okay,
I saw it with my own 2 eyes.
okay.
I kept going and checking, going and checking.
I hear what you're saying, and we are happy to look into it. Okay? I haven't heard this from anybody else. We had a meeting 2 days ago for 4 hours, and nobody else had a similar complaint. We haven't gotten any letters about this or any other persons complaining, so we want to ensure that the
Well, I don't-
results are accurate and that you're satisfied with those results. So to the extent you have issue with it, let us get the specifics so that we can look into it with specificity, and we will respond to you, okay?
I can only give you the specifics that I have.
I understand, and I'm just asking you to do that.
Okay,
Mr. Chair-
there is a level of trust here, and there's also a level of fear to even open up my mouth,
Well, there shouldn't be.
because I don't want to be attacked. Yes, but I got attacked brutally in this election when I told the Democrat Party here in Delaware County different things that they were saying about me. I prove to them without a shadow of a doubt certain things. And since that attack, I've gotten all kinds of threats and things like that.
And
So I'm a little
So
scared.
I want to be respectful to you, and I recognize that things happen during elections and candidates and people attack each other. And without comment on that, that's not our purview to
No, I know,
supervise
but
that. No, wait.
you're asking me why I didn't.
But I'm going to,
say
I'm
anything.
going to tell you, when you come here with something, nobody's going to attack you, because we want to hear people's concerns, and we want people to believe in what we're doing. And I want you to be confident that we're doing things in a proper way. So to the extent you have concerns, I want to investigate those concerns, and I want to get back to you to your satisfaction so that you're satisfied we're doing things in a proper way. Because I've been here for a long time, and I know that we do things in a proper way. And our employees at the board, our staff, most of them have been here for a long time. And I'm confident they do it. And some of our people are newer, but I'm confident that they're doing the right thing. And
How long have you been here?
Have been around, and I think they're confident as well. So we want you to be as confident as we are that things are being done the right way. And
I appreciate that greatly. That's how I felt when I came to the previous meeting. And that's why I got the gumption up to say something at this meeting.
and I appreciate you saying it, and we'll look into it and see what that was, okay?
Thank you.
Yes, ma'am. Anybody else, public comment? Yes, sir. Yes, sir. You know what, and I should have let you speak before. Last year, I let people speak even when we dismissed the objections, because you did take the time to vote, and you did take the time to come down here, and you spent 3 hours, 2.5 hours here today, and you deserve to be heard.
I just wanted to, you were talking about how you're going to go back through and remove those ballots that did not have like box 2 signed.
If there are any, I'm
Right,
not so sure there
right,
are some.
but-
We're going to double check. I
But
tend to
the
think there
original
might not
thought
be
was
too many.
that box 4 had to be signed. So will the others be gone through to see if those that didn't have box 4 signed that were removed should be put back if they
That's
had?
what I asked. I think to be consistent, they would both need to be done. I understand the advice was reversed that you received. I thought that Mr. Chairman did say that. I know he
Oh,
did say,
okay.
I know he
I
did say it
missed
the
it.
second time. He did not say it
okay.
the second time, but
All
he
right.
did say it.
I want to make sure we're consistent.
Yeah.
Okay.
No, it's a fair point. Thank you.
Yes, sir. And, you know, we ask you to identify yourself.
Yeah, Chris Wayne from Collingdale.
Yes, sir.
I was just asked to raise 2 questions today. When will the write-in ballots be publicized?
That's a great question. We're in the process of, we've spent the last 3 days going through 27,000 write-ins, including the ones for Gritty and several other. And unfortunately, we have a policy that I'd like to revisit about recording all of them. So we were, when I was at the wharf earlier today, I believe we had about 3,000 left to go. So hopefully we'll have that completed by early tomorrow, if not sooner.
And then the second question that I was poised to ask was, when do we expect the counting to be done in total?
By tomorrow, so that we may certify on the 18th.
Okay, all right, thank you so much.
Anyone else? All right, seeing nothing else, our next meeting is the certification meeting on the 18th, and thank you, everyone, for your efforts today.
I talk with you more than any of my board members. I respect you. I'm just trying to